ladies and gentlemen, we've had two presentations already. Vincent and Tarek have both spoken from the in-house counsel perspective. I'm external counsel with Herbert Smith Freehills. It would assist me greatly if I just had a view as to the makeup of the audience. Can I just ask you to put up your hand if you are in-house? Okay. Can I ask you to put up your hand if you are from a law firm? In that case, I can sit down. You know this all already. As the majority of the audience are going to be painfully aware, when clients come in with a dispute matter, the typical approach is to want to know three things, to want to know those three things instantly, and to want to know them on the back of, if you're lucky, a half-hour meeting. If you're less lucky, perhaps on the basis of a short WhatsApp message. They want to know, will they win? They want to know how much they will win or how much they will go down for. And they want to know how much the case is likely to cost. The last of those is the easiest to deal with. We've got also, I don't know if you have this, we've got all sorts of fancy spreadsheet things that we use to calculate cost of cases in the office. How many expert witnesses are there? How long is the hearing date, etc., etc. That produces a number which you then ignore and go on the basis of what did the last case I did cost and add a little bit to it. Frankly, that's actually, I think, a very good way of working out the answer. But you can work out how much a case is going to cost. How much is it worth? That's going to turn very much on the facts of the particular case. Some cases are binary. You'll win everything, you'll lose everything. Some cases are much more nuanced. What I wanted to focus on is the first question. It's the fundamental question of will I win? And the assessment of whether you're going to win a particular case or not always turns on the interplay of a series of different questions that get you to the ultimate answer. There's been some wonderful psychology research. Vincent said that this isn't going to be a legal presentation. It's not. There's been some wonderful psychology research on what maths we get intuitively and what we don't. And they can show that newborn babies understand the concept of number far before they can speak. You show babies two things, put up a screen, pull down the screen, and there are three things, and they're puzzled. They realize the number has changed. We don't get probabilities the same way. We have no innate ability to calculate that. Princeton did a study with university graduates where they asked them whether it was more likely, if you tossed a coin 6 times in a row, that you'd get heads, 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 or heads, tails, tails, heads, heads, tails. The vast majority of people said the second one is more likely than the first. In fact, any combination is equally likely. There's a chance of 1 in 64 of anything if you toss a coin 6 times in a row. But we just don't get that intuitively. Clients always come in with a perception. They've been living with the dispute, and they've already focused on what they think is going to happen. One of the things that you can do as outside counsel is to try to break things down and to try and identify what is the actual likelihood of success. Vincent had on his slides a decision tree, as do I. I've not put percentages on mine. Now, you start off with your claim and you may think, well, actually this claim is made up of, I think I've got 6 different claims that go to make up our one big claim. Take this claim. This claim is a claim for payment for variations to the work. Well, we need to actually identify what are the variations. There's a pile of different things, each of which may or may not actually be a variation. In relation to this one, was it properly instructed or not? Oh, well, there are various different possibilities. The way that the maths works is that you identify, well, the chances of this are maybe 50%, the chances of this are maybe 40%. Well, you multiply those together, you're now down at 20%. And so it goes on, and you can come up with some tremendously precise numbers at the bottom. As I say at the bottom bullet point on that slide, please don't pretend there's science where there can't be. When you start going through a decision tree and multiplying all the percentages together, you can quite quickly get to the point where you can report to the client a 17.36% chance of success. That's garbage. Now, I totally agree that the idea of just saying it is a good case or there is a reasonable prospect, those sort of statements can be meaningless. But please don't give the client artificial comfort by pretending that your maths is giving an answer, which it really doesn't do. What can you do? Well, you allow objectivity in the assessment. Again, we heard in the earlier talks reference to anchoring. Clients always come in anchored. They've lived with the case for a long time. They've thought about the case for a long time. They have a perception as to what the answer is going to be. They've got something in their mind, and it's quite difficult to move from it. And again, another bit of psychology research, which I love, as to the importance of anchoring and the number that you have in your mind. Again, a study done in America. A group of judges, criminal court judges, were asked for their views on the appropriate sentence to impose on a criminal, or series of criminals. They were given a series of facts. The person was a murderer, the person had stolen some money, whatever it might be. Before they sentenced the criminal, they had to roll the dice. Just roll the dice. And they found that the people who rolled the dice and got a 1 had a much lower sentence that they looked to impose than the people who rolled the dice and got a 6. There's no connection between what's on the dice and what the sentence should be. But the fact is that the numbers that you have in your mind before you look at something do influence what you think. So the first thing an outside counsel can do is try to bring some objectivity to the process. In doing that, you need to focus on what is the best answer rather than necessarily what is the right answer. I've had a number of clients who will be very, very reluctant to accept what is a tremendously attractive settlement proposal because the other side doesn't admit that they are wrong. But that admission of somebody being wrong is worth 0 for the share price, is worth 0 for the annual return. If you're getting the money, get it and grab it. The other thing that outside counsel, I think, is actually better placed to do than the client by stepping back is to identify the decision points, to actually go through the process and say, look, to get down here to a successful result, these are the things we need to establish. We need to identify, is there a contract? We need to get over the issue that we haven't notified our claims in accordance with the 14-day Qatari time limit, whatever it might be. We can identify what evidence you need to have at each point. If we are going to show we notified the claim, we'll need to have a look at the minutes of meetings, we'll have to need to have a look at the emails. Clients are almost always much better placed than you are as external counsel to actually evaluate the evidence. You can say, look, this is what we need to do, this is what we need to find in the papers. Typically, actually, when clients come in, they've got a pretty good idea what's in the paper. So don't take the whole job to yourself. Remember that you're a team with the clients, and together you can get there. Obviously, you can set the context for the case as to, we heard again earlier on about the time cost of money. How long is this going to take? How much is it going to cost? And you can sanity check the result. You can step back from things in a way that it's much harder for the client to do. It's often much harder for in-house counsel to do. And part of what you can do is be a shield for in-house counsel. If there's an uncomfortable message to deliver, sometimes it's rather easier for the guy or lady from outside to deliver it than the person who's inside. Sensitivity test. What are the key issues and what are the key informations? Going back to that diagram, again, a client is often inclined to focus on the key points about which they feel particularly aggrieved. There was something that happened that was particularly wrong. And often it's a real thing. Again, we had the example of somebody not replying to emails quickly enough. But often somebody has done something tremendously bad, and your client is tremendously upset about that, understandably. But that may not actually be legally all that relevant. So again, as external counsel, you can empathize and do your marriage counsel bit as to the bad thing that's happened, but you can try and bring things back to actually what do we need in order to get to the successful resolution. You can help identify the issues, the uncertainty, and the exposure. you can explain, if you are doing the maths, that a 5% chance is still a chance of success and a 60% chance is not a guarantee of success. Again, that's something that people often get blinded by the numbers. And as we heard, if you're doing one of these analyses, then for goodness sake, update it. The litigation is dynamic, and arbitration and mediation. Facts come to light, things change. An analysis that you do on day one is only worth the position at day one. You've got to update it for it to be worth anything. A note of concern, we do use decision trees in quite a number of the disputes, but garbage in, garbage out is never truer than when you start playing with numbers. There are some things that are tremendously difficult to quantify. There are some things where you simply don't have the information. You just don't know what the evidence is going to be. So don't start playing with it if you just don't have any basis for it. It's not necessarily going to convince those who haven't been involved from the outset, so sometimes you need to walk people through. Risk aversion may still prevail. For many clients, the certainty of a settlement is worth far more than playing with the numbers. If you have got a 50% case, I know that's the figure that you don't like to get. If you've got a 50% case and it's worth $1 million, then that claim mathematically is worth $500,000. But very often someone will want to pay $600,000 to get rid of it, accept $400,000 so that they can get on with their lives. So the math doesn't give you the answer. The math just gives you a position. I've said some lawyers are not great at maths. Again, I was involved in a case, this was actually from my trainee some years ago, where we had the probabilities on various things, and the probabilities added up to over 700%. Chance doesn't work that way. Do go back and double check the maths, and if you're ending up at something other than 100%, there's probably something wrong somewhere. And I'm going to finish with a personal thought. I think that trying to be overly scientific in relation to the analysis is not necessarily the best way to answer the question of should I litigate. I think that the experience that you can bring to bear, some of the intuition that we heard of, is often key as to whether it's actually appropriate to bring a case. Where this is hugely, hugely valuable is where is an appropriate settlement figure. In trying to calculate, is the offer I've got on the table worth it? An analysis like this is actually a really, really good tool. Now, the way that we had said that we wanted to try and organize this session was not to have it as just a series of 3 monologues, but to open up to the floor for discussion and questions. So I will now sit down, but hopefully we'll have an opportunity to say something, because hopefully there will be plenty of questions to follow. Thank you very much.
Thank you.